Hello, everybody. It's Rick. It's Sunday, February the 25th of 2018. My email address is rick, R-I-C-K, 0327 at me.com. Okay, when you send me an email, keep it brief, no long stories. I just deal with child support. Um, I don't deal with traffic or any other you know, legal problems you may have. Um, I don't provide service. I don't work with you personally. So there would be no reason for you to send me you know, any information to your case other than, you know, asking me, this is what's going on in my case. Would you be able to help me? Uh, my paperwork deals with what I'm going to be talking about today, which is a support order that's void, and 99.9% of them are void. Okay, so uh, because they all violate due process. Okay, the Supreme Court held that due process is the law of the land. The law of the land is the Constitution. So I did a video last week telling you guys to learn about to do research and study the Constitution. Also, you should study your state constitution. Okay, it's very, very important because if you have an understanding of the United States Constitution and your that's my cat. She's a spoiled brat. Pretty. She wants me to lay down in the bed and pet her. Um, that the see she threw me off my trend of thought. This cat. Um, Due process requires a trial by jury, an impartial trial. Okay, you're not given an impartial trial if it's a support proceeding where you have a non-judicial court employee called a commissioner, support magistrate, uh, an attorney for the attorney general's office, any one of these posers. And that's precisely what they are. They're posers. It's a it's a fraud setup. It's state. This is my opinion, by the way. All right, this is not proven. So this is just my opinion. So don't go taking what I'm saying right now and putting it in any of your paperwork. Okay, this is just based on what I've seen, and none of it's legal in my opinion, and I haven't been rebutted yet either because I've asserted these things in my paperwork, and no one's rebutted these claims by myself. Okay, what they do is they give the appearance of due process, and all of it's based on presumptions. The number one presumption is you're guilty. Okay, another presumption is because the paying of a public assistance is caused by you for alleged non-support. Okay, you could be paying child support, and the mother or the father, the custodial parent, as they call, could still apply for welfare. Okay, just because you're receiving child support does not mean you cannot apply for public assistance, but it's just the state's way of receiving federal dollars. Okay, the state's participation in child support, federal child support collection and enforcement is voluntary. Okay, so if it's voluntary on their part, that means it's voluntary on your part. Okay, I had one of my subscribers, Angelo, called up he didn't record it, he called up child support people, and then they called him back answering his paperwork, and let's put it this way, he put them in their place by telling them that he does not wish to participate and they require his permission, and they tried their best but they could not rebut him, and he was right. He said, my research has led me to believe, not me, to let me to understand that you require my permission. And the woman couldn't rebut him. That's the reason why they do these proceedings, to make you think that you were ordered to do so in the proceedings. It's all a dog and pony show. It's all a fraud. Excuse me, it's my opinion. It's a fraud. It's a production. Okay? So that's why I'm saying 99.9% of these support orders are void. Okay? Violating due process. So I'm going to show you an order from Connecticut. Okay? All right. Okay, Superior Court of Washington County appears, parentage, okay, petitioner, right? So the petitioner is the state of Washington on behalf of Connecticut, okay? Judgment and order determining parentage, so that's presumption. So their belief is when as soon as they prove that you're the parent or parent, you have to pay child support through their system. Okay, and look what it says here. Judgment creditor, state of Connecticut. Judgment creditor. Judgment debtor would be Mr. Williams here. Okay, so we got a creditor, we have a debtor. Okay, so now, remember I have you guys send in the validation of debt, demanding to see proof of an undertaking. In order for there to be a creditor and a debtor, there has to be an agreement somewhere. Where is this agreement? So this here is proof that my validation of debt methods is on the money. That there has to be an agreement somewhere. So at some point in time, you had to have been offered a contract to repay a loan of some type or repay a service, and that's what this is the case of. I believe the state of Connecticut, and what I have blacked out here is the mother, okay, and apparently the mother is receiving some type of public assistance from the state of Connecticut. But what the hell does that have to do with our friend here, okay, that I blacked out here? They're not proving anything. They're just making a claim. So he has to rebut it. And this is a void judgment. Okay, now let me get on to, okay, order of child support, shall pay support. Okay. And this is just, again, this is just doesn't mean anything, really. Okay. All right. Jurisdiction over children does not apply. Okay. But let me get to the best part to show you why it's void, besides the due process. Okay. Look who's signing it. Commissioner. Okay. Diana Lynn Kiesel, court commissioner. That's not a judge. Okay. That is not a judge. Okay. Here's another reason why it's void. Filed in open court. Pierce County Clerk. What we have here? Deputy. It's void. It's void judgment. It's not legal. It has no legal force whatsoever. All right. And when this guy sent this to me, he's like, well, they validated the debt. And, that's it. My paperwork, guys, is not going to work for you people unless you put the time in. And I've mentioned void judgments many times, but that's why I'm doing a video on it now. Okay, for you guys to recognize if you have a void judgment. Now, this is a void judgment because right here, just on the surface, right here, is a deputy clerk, not a clerk. Okay, a deputy clerk is not a judicial person. Okay, believe it or not, a clerk is supposed to be a judicial person. Diana Lynn Kiesel, court commissioner. She's not a judicial person. She's basically a stand-in for a judge. Okay? It's nothing but an administrative proceeding. Okay? So this is nothing but a void judgment. Okay? Now, another way you have void judgment is violation of due process. Okay? So if you were deprived of your right to a trial by jury, okay, if you were not given the right to speak in court, if there's a court with no jurisdiction, how does a court get their jurisdiction again? Evidence. Where's the evidence that you are not supporting your child? So you can cite as reasons as that the sport order is void. You cite those reasons. The court lacked jurisdiction because there was no evidence before the court that I was not supporting my child. And then we could cite other things like parental rights. Okay, right here. This is a landmark case for us. Troxel versus Granville. Okay, 2000. That's not that long ago, believe it or not. 20 years is not that long ago in Supreme Court land. It cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental rights of parents to make decisions concerning the care, custody, and control of their children. That means you are allowed to support your children in any manner you deem that you deem in your parental skills or your parenting skills or rearing skills. I shouldn't even use parenting, excuse me. Rearing skills. And here's the thing. What overrides this here is an imminent safety concerns. Like if your child is facing imminent danger, that's the only time a court can intercede on to take away your rights to rear your offspring. Okay. Okay. Here's the 14th Amendment prohibits the state, okay, from depriving any person, well, we don't like that word, but the person of life, liberty, or property without due process. How many times do you guys hear me say that? I keep repeating these things for repetition. The court has long recognized that due process clause guarantees more than fairness. All right? Now, if you're serious about learning, what I'd be doing if I was you guys, I would take this and I would research this on my own. All of the people that have my paperwork, you see this document here, you all have it. Hopefully some of you go, oh, I recognize that. This is one of the many things I offer. I offer a lot of things. Okay? Down here, all right, I'm going to show you. And those of you that have this, read it. Okay, let me see here. Okay. The Due Process Clause of the 14th Amendment. Okay, the court has held that the deprivation of fundamental liberty rights for even minimum periods of time unquestionably constitutes an irreparable injury. Okay, that's another reason to if you're being denied your right to due process, which is right to be heard in the court. For those of you, my people out there having a hard time filing the paperwork with the clerk's office. Okay, you have a right to be heard. Okay, and one of the ways to be heard in court is filing paperwork. Okay, so when you run across these clerks that are refusing to accept your paperwork, You're going to tell them that, listen, you're interfering, you're obstructing my due process. I have a right to be heard in the court, and you're also obstructing the introduction of evidence. You're introducing evidence with your paperwork. Okay? Don't be afraid of these people. They should be afraid of you. You're armed now with knowledge. You know more than the average person right now. Those of you that are learning this stuff and you're watching my channel, and those of you that have my paperwork, you are in a better position than the average victim. Okay? So you're armed with this information. Let me get rid of this now real fast. All right. Now, you have avoid judgment. I showed you. Many of you have avoid judgment. If you have... Okay. Get rid of this. Let me X this out. All right. If one of you have an order like this with a commissioner, right? You know how else this is void? This is void. This is a quorum non judice right here. Okay? Supreme Court and Superior Court, Burnham versus Superior Court stated that any proceedings without a judicial authority are void, quorum non judice, because they're before a person, not a judge, and there is no judicial authority present during the proceedings. Okay? And that even goes for some of you that just have a signature from a judge that you've never seen before. That judge was not present at the proceedings. That means that that's a hearsay judgment. All right? But, I'm going to X this out. Now, how do you fight these void judgments? All right? Well, those of you that have my paperwork, you have this right here. It's a notice of motion for relief from a judgment made in violation of due process. Okay? Okay? That's one. Okay? Vacate support order petition. Okay? This is another one you have. Quorum non judice. Okay? This is another. I have different versions. Okay? Written in different ways. Okay? Pick the one that works for you. Objection. Demand dismissal. Okay? If also, when this happens to you, by the way, that last order you saw from the commissioner, that commissioner trespassed upon your rights. Okay? They're not banking on you figuring this out, by the way. So when somebody issues a void judgment against you, you automatically have a trespass upon your rights. Okay? Because it's they're proceeding, they're taking your property without following due process. That's a trespass. Okay? And in that decision of Burnham versus Superior Court, it states that it's a trespass upon rights. Okay, so now you got here, you could file an objection. All right. And also, if you have this, if you want, those of you that have this, you could just remove this objection. Just anywhere you see objection, just remove the objection, and you could just make it notice to the court, demand dismissal. That's those of you that are going through a hearing right now, and there's a support order against you. You could file this. Okay. All right. Notice to the court, the set aside avoid judgment. Okay. Federal Rule 60B. Okay. All of you that have my here it is right here. This is Burnham right here. That's the case I'm talking about. Okay. We announced that the judgment of a court lacking personal jurisdiction violated due process clause of the 14th Amendment as well. That's a 1990 case. This is the Supreme Court saying this. This is not your opinion. So this is in your favor right here. Okay? Let me The proposition that the judgment of a court lacking jurisdiction is void traces back to the English yearbooks. All right, we're talking, this is before the formation of the United States of America. Okay, this is going back to the King George days. Okay, and it was made settled law by Lord Coke. Okay, that's let's put it this way, in the annals of law in the English-speaking countries under the Crown, Lord Coke is a well-known man. Okay, you'll see his name in almost a lot of courts. You'll see like quotes from Lord Coke. It's not uncommon to go to a federal court and see a quotation on the wall somewhere in a court from him. Okay. Okay, traditionally that proposition was embodied in the phrase coram non judice, before a person non a judge, meaning, in effect, that the proceeding in question was not a judicial proceeding because lawful judicial authority was not present and could therefore not yield a judgment. Okay? No judicial authority, no judgment. Okay? All right, I X that out, but that judgment by the commissioner is void. It has no legal authority. Never did. It's nothing but a fraud. But now the hard part is getting a court to actually do its job and not protect one of its own. Okay? That's where the fun part comes in, but I showed you the documents to file. Another way to fight this, avoid judgment, is filing a writ of habeas corpus, because your liberty is being restrained by a void judgment. Okay? Okay, so again, could not yield a judgment. American courts invalidated or denied recognition to judgments that violated this common law principle long before the 14th Amendment, because we have a due process clause in the 14th Amendment. But the courts, before there was a 14th Amendment, okay, even before there was a Bill of Rights, they recognized that any judgments that violate, a common law principle is void. Okay, any judgment that violates the law is a void judgment. Okay. Okay, 1 second here. We announced that the judgment of a court lacking personage violated due process clause of the 14th Amendment. Okay, and that's a trespass. So that judgment I showed you guys earlier, if you could sue that commissioner and introduce that judgment, that void judgment, as evidence. All right. But listen, it's not that simple either. I mean, these people are so protected by these judges. They have so many ways of protecting each other. So you have to really do your homework on that. I mean, I have people asking me to write up paperwork for them for that. And I'm going to be honest with you, I'm not ready to do that yet. That's a lot of work. Okay? I haven't even sued the people that screwed me over yet. Okay? But it's a big undertaking. Okay? And it's stressful. Right now, I'm dealing with trying to help you guys. It's a lot of work by itself. Okay? So all of you out there, if you have I'd say that you all have void judgments, okay? And you should all start thinking about filing the paperwork that I showed you, okay? Please, guys, you're going to have to start doing your own homework. I'm getting way too many of you guys asking me questions that you should know the answer to, okay? I can't hold your hand, okay? All right, let me just read this real fast. The duties of the American courts: ensure that this matter is adjudicated in law and equity arising under judicial powers of the Constitution, the laws of the United States. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States. Article 3, Section 2. That's the duties of all courts, by the way. Okay? And I'm going to slow this up and you guys can read this. This is for those of you that don't have this. But all of you have, if all of you have received my paperwork in, it's probably saying the last 6 months, you all have this. Okay? And here's another thing. All right? If you got my paperwork about a year ago, okay, I'm not Apple, all right? When I come with new paperwork, it's not like, hey, Rick, I donated to you, like, like when Apple does its updates, it's for free. When you get the paperwork from me, it's kind of as is. A lot of times I'll send it to you as a courtesy, but, a year ago, you know what I mean? I get people all the time. Hey, Rick, can you send me that thing? I got, like the dog ate the homework excuse. My computer, it's deleted it. Whenever I send you this stuff, it comes in email attachment. As soon as you uh, click on it, it should automatically be downloaded into your computer. So I don't know how you're losing these documents. Okay, you should be saving them right away. Okay. And listen, if I gave you the paperwork about a year ago, I don't know what you're waiting for. Get to work. Okay. All right. And that's about it. All right. I mean, I just showed you guys you have avoid judgment. All right. It's 26 minutes into the video already. Also, do your own homework. Look up void judgments. There's plenty of information on the internet about void judgments. But undoubtedly, you all have void judgments. Okay. All right. If it's not signed by a judge, void judgment. If you didn't have a trial by jury, void judgment. Okay. That's just the way it is, and you have to hold your ground. You got to, if they say, well, we don't have to give you, like, no, you do actually. Was the right to a trial by jury you just say, I didn't know the Constitution of the United States was suspended. When did this happen? When did the Fourth Amendment? Excuse me. When did the Seventh Amendment be become suspended? When was that? When did that happen? That's the right to a trial by jury in any controversy of $20 or more in civil proceedings. If you're going through criminal proceedings, you have a right to trial by jury under the Sixth Amendment. Okay, so that's that. Where this comes into play by learning the Constitution. Okay, again, I can only help you. My paperwork only goes so far, guys. Your knowledge has to play into this. Okay, and when this guy sent me this, he had no idea he had a void judgment in front of him. Okay, he's a nice guy. I'm not saying anything bad about him, but he's I asked him, I go, what do you have? He goes, well, he validated the debt. I go, no, they didn't. He had a void judgment, and I've mentioned this many, many, many times in my videos. But when I make these videos for my health when I'm driving in the car, I don't do it so I can look at my face while I'm driving in a car. It's repetition and repetition and repetition to teach you people. But if you're not going to watch my video past the 5-minute mark, you're not going to learn anything. Okay, I mean, I check the stats of my videos, and after 6 minutes, the average person is gone. So how are you going to learn anything if you're not going to put the time and listen? What else you got to do? Listen to music, okay? Listening to music ain't gonna free you from your problem, guys. Okay, you gotta put the time in. Okay, I told you, I put about 2,000 hours into this stuff. All right, I didn't learn this stuff by accident. All right, guys, enjoy the rest of your Sunday.